So thank you very much for rejoining us. We're now going to go into the second half of this, which is really kind of a more in-depth discussion related to advanced care planning and kind of the legal and ethical obligations around what we have as practitioners to be able to facilitate the proper completion of the documents and respecting and honoring the patient's preferences when they actually complete their documents in whatever form that they do. So we want to start with kind of the categories of advanced care planning, go into a little bit about what's important to families, and then some factors that we have to make our assumptions to move forward. First of all, the center, and this is kind of a perspective of the center and how we kind of think about it in the last 30 years or so that we've been doing it. As I mentioned, I think early on that the wellness and prevention aspects of this are really for the healthy 65 and year older and adult, or any adult, him or herself, who looks at advanced care planning and says, well, yeah, I know I need to name an agent, or I want to name an agent, and I know who it is that should speak for me when I can't speak for myself. And I've got some pretty strong feelings about what I do and don't want in terms of treatment, but I want to reserve those specific instructions until I actually have something happen to me. So really the importance of having a conversation with the loved one is there, but we basically don't want to think about it because it's too hard to think about in general. And then the other category is what we've been talking about this morning, is the real importance of having goals of care discussions for those that are further along on the healthcare continuum. They've either got a chronic condition already, or multiple chronic conditions, or have had serious illness, life-threatening illnesses in the past, maybe a bout with cancer, a heart attack, serious heart attack or heart disease, and they are basically kind of dealing with their own mortality. And that goals of care discussions for them are different than the wellness and preventions, the more theoretical discussions that those of us that are earlier in the stages of life don't necessarily think about. So you can think about those as being kind of two different categories of discussions that we're going to be looking at. The other areas to think about in terms of the three elements is that all of us related to advanced care planning and to our own health, think about life in kind of three quadrants. The independence factor, what do we consider to be important to ourselves in terms of being an independent individual and not being dependent on others so much or focusing on interdependence rather than dependence on others. Those are very important for most people. Quality of life that get defined by each of us in different ways depending on our status in life and state. And then, as we talked about most of this morning, the functional status. Where are we in relation to how we see ourselves being able to function, and what are the most important things to us? So I want to give you three very quick descriptions of folks and we always consider, there's good evidence that all three of these elements are important to everybody: independence, quality of life, and functional status. And those change over time, not in the importance to those individuals, but how those individuals recognize independence. So as where an elderly person like my mom, independence was pretty much defined as the ability to drive a car and the keys that she held in her hand in terms of being able to decide where she wanted to go and when she wanted to do it. My mom drove, I think I figured out as when we sold her car recently, because she has given up the keys, I think she drove 6,600 miles in the span of 16 years in the vehicle that she owned. So it was like, 400 to 500 miles a year. And it was unfathomable to me why she just didn't rely on cabs and other things like that. She lives in a city where she could easily have done that. But for her, the definition of independence was associated with her vehicle, and it is for many of us as well. Later on, her independence became more in terms of being able to decide where she lived. When she moved to assisted living, she wanted to make sure that she had the right place, that she wasn't necessarily having to be roped into all of the social engagements and issues that were going on. And she wanted to be able to, again, define herself in terms of how it is she wanted to live her life in that setting. So independence didn't become less important for her, but how she thought about independence in relation to her health status and her condition was very important. The same is true with quality of life in terms of the kinds of things that we may want to do, our children and our grandchildren, and being able to get down on the floor and play with them may be a very important factor in relation to quality of life. Whereas before it was being able to pick them up and hold them. It may not be so much that anymore, but we still are able to define quality of life in that status for ourselves, depending on where we are in our health trajectory. And then finally, the functional status. And this, a good example of this is, again, my functional status may have been that I, walked a 5 mile or a 5K marathon or something like that with my grandkids, for my husband who died of heart disease. And now it's being able to toilet myself and being able to get up from my bed and make it to the bathroom on my own and get back into my bed. And that's very important for me. So I want to be able to maintain that. So again, functional status being important, but how that gets defined being very different. And then there are 3 factors that we need to pay attention to in advanced care planning in terms of presumption of capacity, competency, and surrogacy. So let me quickly cover those. The ethical requirement is that we always presume capacity for any individual that we're working with. And that even if the patient is incapacitated, there is a fiduciary obligation, a moral duty that we have to involve that patient as sufficiently as possible in whatever decision-making process occurs. So even though you are deciding for your mother who has advanced dementia, there is still an obligation that each of us hold for our obligation as an agent to make sure that we involve our mother in whatever capacity we can in that conversation about what's going to happen and what kind of treatment. That we never surrender the legal obligation or the fiduciary obligation to assume that they can participate in a decision as much as humanly possible. Competency is a determination that is adjudicated. So it's a court-determined thing. So capacity is determined by a clinical assessment, usually by a physician, usually through an instrument or a process. Competency is actually a decision that's made in the court setting, and we often use those terms interchangeably and should not. So competency really is a decision that it usually requires then, as a result of declaring an individual incompetent, usually appointment of a guardian or a conservatorship in order for us to be able to proceed with the individual. And then surrogacy is also an important factor to consider. Neither the state of Missouri nor Kansas has a surrogacy statute. So we don't have in either state a pecking order that we use to determine who gets to make a decision by default. And we're one of the 2 states in the nation that hasn't gone through this process. There are very few other states that haven't done it. And right now there is no move that I'm aware of. And there have been some attempts in the past, as recently as I think 2014 in Missouri, and might have even happened again last year, I'm not sure. And then in 2009, 2010 in the state of Kansas, where there was recommendations in putting into statute a pecking order that we would be turning to. I think as we move away from this kind of legalistic approach to advanced care planning, we are trying to kind of gather around the people that are most important, especially those that have been named by the individual, if we can get more and more people to do that, to allow those surrogates to be facilitated by that individual, and then bringing the people together, the moral agents together that really are important for us to be able to involve in any kind of decision that we make on behalf of another. So what are the documents that we look at? The first one is called the Durable Power of Attorney for Healthcare. That is different than the appointment of a regular power of attorney or a durable power of attorney for financial matters. It is actually limited only to healthcare decision making. It does not have to be in any kind of a document initiated by an attorney, where most other durable powers of attorney are named and the powers and distinctions are delineated. But it is important that the powers be identified that we're appointing our agent to be able to assume, and any reserved powers that we're holding back from that individual if we want to maintain those ourselves, or we're saying that we only want you to follow an instruction. So let me be clear in terms of kind of some differences between the Kansas laws and the Missouri laws on that one. In most documents for appointing an agent, you'll see the powers kind of listed automatically, and the powers to make decisions related to life-sustaining treatment are usually listed as one of the powers that are delineated for the agent. In Missouri statute, that is a requirement. If you want your agent to be able to make decisions for you, you actually have to have in your document a specific reference to the fact that that person has that power. In Kansas, you do not need to actually indicate that, as long as you give all powers and reserve no powers for yourself in terms of the appointment of your agent on the Kansas side. In addition, on the Missouri side, there needs to be a notary when that event occurs, and in Kansas, you can notarize it, but you can also do it through the witnessing process. On the effective date, both states have differences related to as what they call springing event. In Kansas, you can make that effective by a particular date, the date of execution, or you can make it based on a particular date that you want it to occur, or a particular event when I can no longer recognize you, or something like that. So that's a possibility within the Kansas statute. On the Missouri side, you can only have an appointed agent act on your behalf when you can no longer make the decision yourself. So there has to be a capacity determination made at the time that a Missouri durable power of attorney agent actually becomes launched or live. It doesn't have to be a long involved process. It's just basically saying that there has to be some documentation that the patient no longer has capacity by a clinical individual who has the ability to make that determination. A living will, which is what most of us call the healthcare directive, is basically the document that describes what kinds of treatments or what kinds of plans that the person has related to kinds of the goals that they have related to their care. And again, as I mentioned earlier, there's always a presumption of capacity related to a living will, so you can't go around waving it in front of somebody's face about, my mom doesn't want a feeding tube, if your mother is still capable of answering whether or not she wants a feeding tube, even though it may be listed in her living will as not wanting one. So I just want to make sure that we understand that. I know that a colleague of mine, Kathy Greenlee, who's now on staff with us, but it was the Ombudsman and the Secretary of Aging secretary in Kansas for a number of years, said that the thing that drove her crazy the most was when family members would walk into a nursing care facility, long-term care facility, and waving the advanced care planning document and stating that they were going to make decisions for their mother when their mother was perfectly capable of making her own. And the staff at the nursing facility was trying to basically intervene on behalf of the patient, and the agent was declaring that they had the capacity and the ability to make those decisions. And we really don't. There's again, as I mentioned earlier, the presumption of capacity is there, and if the person does have the ability to do that, they can do it. That capacity doesn't have to be completely A to Z. Capacity may be simply the fact that I know you're my daughter, and I know I love you, and I know I want you to make my decisions for me, and it's okay with me that you do that, and I want you to make the decision in this case. That is basically still capacity, and then the individual has the ability to facilitate in the process of making the determination related to the treatment that's being projected. Advanced care planning concepts and principles. These are pretty much the ethical principles that we used throughout the history of bioethics. First of all, the principle of autonomy, and that we are self-directed and self-ordering people. And as long as we can do that, we should be respecting that for any individual who has that ability. And again, that autonomy may ebb and flow and wane over time, and especially those that are dealing with dementia issues. But we still need to make sure that's the reason for the fiduciary obligation to check on capacity, is because that autonomous individual should be able to make those decisions related to their own care when it's possible. Now, there may be subtle distinctions related to that. I know in our case with my mother-in-law, she was a very compliant patient with advanced dementia, and you could have asked her if you wanted to, would she like for you to set her room on fire, and she would have said yes, because she saw a smile on your face. But obviously, we need to be able to make determination in terms of the assessment that we're making, but involving them in the discussion as much as possible is important. As I mentioned, the distinctions between competence and capacity are there. There needs to be a determination of capacity by a clinical individual, and that the determination of competency actually takes place through the adjudication process with the court intervening and then a decision made about guardianship and conservatorship. It is, and usually those competency questions are only related when there's challenges. So a person can go from capacity to no capacity, and that individual making decisions on their behalf never has to seek a guardianship, simply because the powers have been delineated and recognized and awarded. So there's no reason to seek a guardianship unnecessarily, and it's a very expensive process. And if there's no challenges or concerns related to the kind of care or abuse questions or anything else, there's usually not a problem allowing individuals who lose capacity to be able to provide that transfer of powers to their spokespersons and agents. So here's the definition of capacity. That is simply the ability to understand and appreciate the nature and the consequences of the healthcare decisions you're making. So that includes benefits and risks. So it's a little bit more subtle than kind of I suggested earlier, that, you know, I know you and I love you, but basically being able to back up from that and to say, can this person describe for me what it is that I'm asking them about their, you know, undergoing surgery or a specific kind of treatment? Do they understand, and can they talk about the benefits and risks? And if the answer to that is no, then obviously there has to be somebody else assisting him in that process. And the ability to answer that complexity of the question obviously needs to involve a shared decision and not just an informed decision by the individual. So again, there's no kind of legal check box that you have to go through here. These are more kind of the ethical and fiduciary obligations we have as agents and loved ones. And within the setting in Kansas and Missouri, where there's no actual pecking order in terms of who gets to decide, the clinicians and the providers need to make sure that the moral agents are assembled and making sure that we're making good decisions as we go through this process, and that we have as many of the people involved who are going to make noise or be need to be involved in the decision, are involved in the decision as we move forward. Susan, you have any comments you want to make in terms of the long-term care setting on this? I think you're still on mute if you want to.
One of the things that I think we have to be very careful with in long-term care, many people I've talked to nod their head when I say this. We have a tendency, I think, to seek out the person who will give us the answer that we want. And we have to be very careful that we are, in fact, dealing with the resident up to their capacity. So we just can't turn around and on this day, because we'll get the answer we want, go to this daughter, and on this day to this daughter. We really have to pay attention to this capacity piece. The other thing I want to mention in here, John, is the living will. The wishes of the living will need to be put into physician orders for the nursing staff or the healthcare staff to carry out their will. The fact that it's in their living will is not a physician order. So I think there's sometimes confusion about that. So it's important that the particularly long-term care know what's in the living will, and that they have an order to cover what is in that living will. So I just want to make those 2 points.
And I think it's a very important distinction, because there's also this question then around the out-of-hospital DNR. And so those directives on the Kansas side, or those orders on the Missouri side, obviously need to be integrated into the care planning and the goal setting that occurs within the long-term care setting. And we'll be talking more about that in the future as well. But those are very important elements to make sure that are reflected, as you said, not just in advanced care planning documents, but translated and transferred into the physician orders. Okay, this is a very busy slide, and the source that's at the bottom of the page is actually the location that you can go to find it. But what I wanted to do was at least give you some kind of a description or basically documentation about who gets to decide when a healthcare decision is being made, and there is a guardian and a agent both involved in the case. So in Kansas and in Missouri both, the person who actually has the final authority to make the decision is the guardian in that case. Now, in Kansas, the reason for that is because the law actually stipulates that the guardian, when the guardianship occurs, actually has the power to appoint and remove the agent. That is not a requirement, however. So if the guardian gets guardianship and the agent is already in place, there is no requirement that the guardian make the decision related to the care if the guardian is confident that the agent still is going to act on behalf of the patient in a consistent way related to their goals or their authentic expressions that they've shared in the past. So there is no requirement in Kansas that you undo a appointment of an agent if it is different than the guardian. But I just want to make sure that you understand that the guardian actually is the agent, the agent that actually gets to make that decision, and it's up to them. In the state of Missouri, that is also true, that the guardian has the duty to assure that the ward receives the medical care and other services that are needed. And that's kind of a blanket statement that they make as well. So the guardian gets to make that decision as well within the state of Missouri. So there is no prohibition from an agent appointment when a subsequent determination is made for a guardian, but if there's a conflict, the guardian actually gets to be able to kind of trump that decision. I'd quickly like to cover some discussion about kind of myths that are associated with decision making. For those of us that are dealing with patients in whatever capacity that they may be when they come to us, and just kind of make sure that we cover some ground here to make sure that everybody is on the same page. First of all, we've talked about earlier that capacity and legal competency are two different things, and I hear a lot of confusion about this in long-term care settings, especially that the patient isn't competent anymore and we need to be making decisions for them, and the term actually should be capacity if they don't have capacity because there's been no adjudication and no competency hearing held, and that really should be a kind of a adjudication process rather than a clinical process. That the lack of decision-making capacity can be presumed when patients go against medical advice. That's not necessarily true. We do not have any protections in law that keep people from making bad decisions. If people want to make poor decisions, there's nothing that says that they don't have a right to do so, and it doesn't mean that they don't have the capacity to make decisions. Now, it may be an indication that their ability to make decisions or good decisions is at risk, but we can't automatically assume that just somebody who goes AMA no longer has capacity. Especially for those who have mental illness or accompanying illnesses related to the ability to make decisions or had difficult histories in the past in terms of behavioral issues. There is also no need to assume that unless patients go AMA, that decision-making capacity is gone. So just because they leave against medical advice doesn't necessarily mean that the patient's decision-making capacity is kaput. Also, decision-making capacity is either all or nothing. As I mentioned earlier, there's this kind of continuum of care, and consent is important, and understanding the issues are important. The complexity of the decisions obviously are important, but it can be somewhere along that spectrum. And as long as we have those expressions of the past, and we've done our homework in terms of eliciting those kinds of decisions and preferences, and we should be able to honor and respect those that are laid out by the declarant. And that cognitive impairment does not necessarily mean lack of decision-making capacity. So, because again, the cognitive impairment may be episodic, maybe in the morning versus the evening. So we need to, again, back to the issue about our fiduciary obligations and making sure that we're kind of walking with the patient is important. Also, that once you lose capacity, that you've always lost capacity. That's not necessarily true in all cases. And the most common basis is if a patient goes under surgery and anesthesia, that the person, their substitute decision maker, actually makes decisions for them, and that the patient doesn't regain consciousness or doesn't regain consciousness right away. That doesn't mean, obviously, the decision-making capacity stays with that individual for the rest of their life. If they regain consciousness and decision-making authority, it automatically resumes, and there's no problem with that. That's not so true with adjudication of decision-making capacity related to competency. Patients not given relevant and consistent information about their treatment somehow lack decision-making capacity. That's really our job to make sure that they're getting the information they need in a manner and a way that makes sense to them, that they're able to make decisions that are consistent with their goals. And that's really the burden that we have as clinicians in making sure that we provide that to them in a way that's understandable to them, that's broken down into meaningful segments so that they can make decisions and match those treatment plans up with their goals of care. And that patients with certain psychiatric disorders automatically lack decision-making capacity. That's not necessarily true. Or involuntarily committed patients lack decision-making capacity. This particular list was generated by those who work with veterans and has been used in many training programs for patients who suffer from traumatic brain injury and trauma as a result of a military injury. So these are coming with, I think, well-founded and resourced findings around the myths. Other decision-making considerations that we need to make sure that we're all aware of is this diminishing over time and the episodic, which we kind of talked about earlier, the morning and the evening, or the involving patients when they can make declarations and instructions in a way that's consistent with who they are. So there's no right or wrong, good or bad, and yeah, we need a checkbox and we need a decision and all that kind of stuff. We understand that in the course of the day. That doesn't relieve us as providers of making sure that we're able to involve the patient in a meaningful way as much as humanly possible. And finally, the principle of subsidiarity, which simply means that the decision should be made at the least, the lowest level of the situation as possible. So if it can be made at the patient's level, then it should be made at the patient level. And if you need to go up from there, you go up from there. That's also the principle of subsidiarity, addresses kind of the hierarchy that we have related to following instructions. So our job as agents is to specifically address any instruction that we're given. If we don't have that, then we move to what's called the principle of substituted judgment, which is, okay, my next step is, you've told me before that you did or didn't want something, then I am to follow that. It's not up to me to decide whether we follow it. It's up to me to honor your instruction and then your wish. And if it's not specific, at least you've told me in the past, when this kind of thing happens, I want you to say yes or no, or do this or do that. The third level is the best interest policy, which is the principle which is actually involving the clinicians in the process and saying, what do we need to do to make sure that the kind of person that this individual is honored, and we're able to make the decision in terms of the treatment plan, because no instruction has been given related to that. So that is always at the lowest level. The competency hearings is kind of the end of the line. Guardianships and conservatorships are things that we go to only kind of as a task of last resort, and that we're really hopefully going to be able to continue the involvement of appointed agents in that process. So let's talk about a little bit about our obligations that we have in terms of what we're supposed to be doing related to the obligations in advanced care planning. The first is explaining different kinds, making sure that the families and the patients we're working with understand the difference between the two, that there are basically two, that the agent appointment is certainly much, much more important for us, so that we've got somebody who can speak for us when we can't speak for ourselves, than the healthcare directive. But as Susan mentioned, if there is a healthcare directive, especially for those patients in long-term care, that the job of that agent is to make sure that those expressions get translated into physician orders, so that the medical team and the providers are able to honor those instructions in the same way, hopefully, that the patient would, and we're not doing it at a 3 o'clock in the morning emergency response because we don't know how the patient feels about attempts at CPR, so that we're consistently approaching that. So even though there may not be an emergent situation, impending, there is still a responsibility that the agent has to make sure that advanced care planning descriptions and wishes are translated into goals of care for the treatment plan in the facility and any physician orders that may come as a result of that. So using examples of goals of care and treatment matches hopes and expectations. That's a dialogue that professionals should be involved with the patient, using hypotheticals, using descriptions of kinds of things to make sure that you're getting concurrence related to the kinds of situations which you know routinely or happen episodically, and making sure that there's a good understanding on the part of the family member or the decision maker or the patient, him or herself, in terms of what they would want or not want. And then addressing ethical obligations for determining the medical necessity, which obviously is driven by best interest. So you don't have a particular instruction, you don't have a checkbox on the advanced care planning document, then we're really kind of subject then to medical necessity. And that should help. Their determination by best interest should be made in consultation with the physician and the team. Susan, you look like you want to say something.
I think this is where we get down the road of sending the person back to the hospital and into ICU, because without any previous discussion or understanding of what the patient and our family wants, clinically, the best interest is always to do as much as humanly possible. So, and not that that's wrong, I'm just saying that this, to me, is one of the areas that shows how much we need to have this conversation early on in the course of the disease. So that's all I want to say there.
Right, because absent any discussion, best interest defaults to the default system. So medical necessity takes over. So I think that's a very good way of kind of reversing the whole thing, to say, if you've got good discussions, then best interest can play a very important role in determining medical necessity at that time. Absent any of that, the only thing we have is default medicine and rescue medicine to guide us in our behavior, which may not actually be in the best interest of the patient, but it's the only thing we have to fall to if we don't have any of that other information. And then finally, a suggestion that we have, not only in terms of what we talked about earlier about dropping the term end of life, we would really suggest that you also eliminate from your lexicon vocabulary the reference to the term futility, and that really we should be talking about ineffective kinds of care, burdensome care that may actually be projected or suggested that may be, or rescue medicine, and be able to talk about those kinds of terms so that the patient can understand what it is that benefits them in the process of looking at any kind of treatment. All of us are going to want to say, well, I don't want to lose mom, and I don't want to have her die of a heart attack and never be able to say goodbye to me, and those kind of things. We understand that, but when a patient is in a progressive course of disease, we need to make sure that we understand what's going to be ineffective in terms of the kinds of things that end up with people landing in the ICU and that kind of thing, and then everybody's scratching their head about, how did mom or dad end up in here?
John, I might mention, I'm maybe preaching to the choir here, but I think it is always good to remember that many of our families and the patients and residents come to us with an understanding of healthcare that they have obtained from the TV world, and so they really don't understand or know. I don't know about understand, but they don't really know what goes on with a full-blown code. They don't really know what goes on with some of the things that we use in our everyday language, and we need to really try to explain to them in phrases and words that they can understand, and not make any assumptions because they're not in their heads that they really do know what's going on and what we're talking about. I remember, and this is kind of off the beaten path here, but my husband had a pulmonary problem, and he went for a pulmonary test, and the tech asked him how many pillows were on his bed. Well, his eyes got real big, and he looked at me and he said, "Oh, I imagine about 15. Well, he was talking about decorative pillows when the tech was talking, how many pillows do you use to sleep? So those kinds of conversations and the miscommunication I think, happen more than we really want to admit. So if we can really try to articulate in the understanding the progressive disease, understanding what those interventions really look like, not necessarily what they may perceive they look like based on their TV experience. Just food for thought.
Right. And I also think that asking them to describe what it is that they think would happen in an event is the first step that you should go through. I've heard a lot of criticism around, especially in long-term care setting, you know, kind of using the club of scare medicine, scare tactics to kind of shake people to the core about what's going to happen if we were to call 911 and we start a resuscitation attempt. It may not be pretty, but we also don't need to use that to scare families in terms of the process. So I think, as you suggested, getting an understanding from the family and the patient about what it is that they think those things might do, or how those things might benefit the patient, what the goals would be in the process of being able to do that, are very, very important. I had a case recently where an individual has a pacemaker, and he had multiple cardiac events over a number of years, and he wanted to be a DNR, but he still had his pacemaker in, and the family was trying to figure out whether they could, and he was in a daycare setting, and they were very concerned about an episode occurring and then things happening that shouldn't happen, and intubation and those kind of things. And there was a lot of confusion and a lot of questions and concerns that she had and her husband, the patient, had in their own understanding of what might happen if an event occurred. And only when she was able to kind of sit down with me and a few other folks did she really get a much better picture of the intervention and what might occur and in the situation that she was in, and whether or not they would or would not want treatment. And she had a lot of confusion. I mean, there was just a lot of misunderstanding. And this was a patient who'd lived with this disease for a long, long time, but had never had an episode as serious as the one that they were thinking might happen next, and they wanted to know what they should do. So those kinds of discussions are very important, and I would really suggest that you start with the request of having the family or the patient describe to you what they understand as those things meaning, in order for you to be able to clarify and to provide some additional information in terms of, well, maybe it may not look quite like that, and we need to be able to do a better job of helping you understand kind of where things might go and what decisions we might make when that timing happens. So the other obligation we have is making sure that informed consent is a process that's arrived at. Most of us have those requirements within our own institutions, but again, making sure that the patient understands the burden and the benefit and the risks and those kind of things associated with the treatment or the intervention, in order for them to consent and fully consent and be able to say, yes, I do or don't want something. And then, as we talked about almost all morning, just understanding where they are in the disease process themselves. How sick am I? And what do you know about your illness? What are you afraid to know about your illness? What do you think the next steps are? Getting the patients to be able to describe that. There's a series of about 6 or 7 questions, which involves even things like, what do you not want to know? And who do you want to have that information if you are reluctant to receive that information? So all of those kind of things need to be expressed and kind of delved into and decided during the process of going through these final decision-making steps. Acting on behalf of the patients, when does that happen? When doesn't it happen? How do we modify goals of care? How do we involve family members in that process or other individuals? And when agency actually takes effect and when it doesn't. And I know this has been a big question, especially in long-term care in Missouri, where there's a appointment of an agent, and yet in many cases there's an assumption that that living will or that, and again, it's back to the law in the state of Missouri, which says your living will does not go into effect until you can no longer make decisions for yourself. But that doesn't mean that there can't be a participation by the agent in helping make sure that there's an expression of what's going on with the patient and honoring the patient preferences and wishes as an individual agent in terms of helping explain what it is that the patient actually wanted or didn't want, if that patient is fully informed and if the agent is fully informed in terms of the expressed wishes of the individual. So the principles of dignity and integrity, which are very, very important for all of us, including our own best interest and self-interest, is to protect the patient, making sure that we do our job in protecting the proxy decision makers so they're not exposed unduly to accusations of ill treatment or abuse and those kind of things, so that we're working with them and not against them, or making sure that they're involved in that process. I will tell you, I had a very, very difficult case in the last 3 months in which a woman had made it very clear that she was refusing basically any and all treatment. Her daughter took it very seriously, that that's what she wanted, and her daughter continued to try to refuse treatment for her, including antibiotics and other kinds of things in a long-term care setting. Her daughter was removed as her medical decision maker, and an agent, a guardian was actually appointed to protect her. And the difficulty was that the facility and the agent were never able to resolve the questions and issues around the initial decisions that the woman had made related to her refusal of treatment early on in her care. And they saw themselves as participating in an aid in dying process. And I've got to tell you, when I was having conversations with her, I was having some of those same qualms myself, that I thought she was refusing reasonable care and really good palliative measures simply by the fact that she was saying she doesn't want anything. And it made me nervous as well. But again, I think what happened in that case was we failed to really involve the proxy decision maker early enough on so that they understood why they were doing things for the patient when they were doing them. And the woman was quite distraught when she called me and sobbed a number of times during the course, because she thought she was never going to be able to see her mother again. She deeply loved her mother. Fortunately, the guardian that was appointed did continue to involve her in the case, but she felt really kind of disenfranchised from the whole system when all she thought she was doing was really honoring medical decisions that her mother would have made in terms of refusing treatment. So understanding shared decision-making obviously is important in this process, and making sure that we've got informed consent, that we're doing a good job of documenting when that has occurred and when it hasn't occurred, and when we don't yet have it, so that we continue to stay on the path of making sure that we get it. The importance of advocacy, not only for ourselves, but for the proxy decision makers, and making sure that we interpret expressed wishes of the patient in a way that's consistent with what the patient wants. Excuse me. So the big question then is, how do we interpret wishes which may not be very clear to us, or even maybe to the decision maker, the agents? How do we make sure that we do a good job of recognizing values and preferences, and then how do we elicit those in a way that makes sense for us as clinicians? Excuse me. And identifying and honor treatment goals, making sure that we validate the dignity of that individual and integrate cultural and ethnic differences into our decision-making process. And this has to do a lot with language barriers, and those that have been disenfranchised, maybe not, or always never really been able to access the healthcare system in a way that we have, and fears about their ability to be able to receive treatment in a way that's consistent with what they want or that would be offered to other people. So those are big challenges that we face in healthcare, especially at the end of life, and not only in the acute care setting, but certainly in the long-term term setting as well. So Susan, any comments on that kind of type? We're going to move on now into the DNR.
No, I think that thank you. I covered that very well. Thank you, John.
All right, so let's get on to what exactly is a do not resuscitate order or directive, and what is an allow natural death order and directive, and hopefully be able to explore a little bit more on the legal and standard of care distinctions between the two. A number of hospitals have embraced the allow natural death. It's a more positive and proactive stance than the do not resuscitate, which is more of a negative, manner in which to take care of what a patient's wishes are in terms of what they do or don't want related to resuscitation. And may also, if allow natural death, may cover additional treatments in terms of life-sustaining treatment rather than just resuscitation. So the biggest problem we have with resuscitation, obviously, is that it is limited to the single activity of trying to revive a patient. Although medical professionals have done a pretty good job of generalizing that order to mean, unfortunately, in some cases, do not treat. but it is not. Do not resuscitate obviously is limited only to a resuscitation attempt, and allow natural death allows us to be able to talk about things other than resuscitation, which I know has been welcomed in many acute care settings to allow the patient to be able to express wishes around feeding tubes and other types of interventions. But I'd also like to spend some time now drawing some major distinctions between directives and orders, patient directives and physician orders, which are entirely two different things. So in addressing issues of burden and benefit, the patient is the final arbiter. They're the one who get to decide whether or not something is burdensome or not. We can decide whether something is an effective treatment based on the clinical path and trajectory of the patient, but the patient actually is the final arbiter of whether burden or benefit. There are obviously social dimensions and social justice issues that relate to burden on behalf of the system that we may want to express, but the actual treatment intervention in terms of burden benefit rests with the patient. The uncertainty in the surroundings, effective treatments, and the rescue medicine in the final stages of illness are well known and well documented, but in many cases, as Susan pointed to earlier, at least in the clinical environment, in the professional environment, but they're not well known in the family environment. Many of them base their decisions on the effectiveness of rescue medicine from watching television. And patients walking out of the hospitals, 30 minutes before the end of the hour or whatever, the television show, and they're up and around and walking well. And that obviously doesn't happen, especially for those in the final stages of illness. So again, making sure that that uncertainty is resolved and that there's effective means of communication around that. Also, attitudes about relying on medical science and technology. As professionals and those in the field, we are much more accepting of medical science and evidence-based approaches to medicine and technology as being effective means for us to be able to achieve things. So oftentimes we'll put those forward as ways for us to be able to achieve an outcome. Also, not so much medical science, but technology. Americans, it's well documented that Americans have a love affair with technology and the latest, greatest intervention. And so we end up utilizing technology in some cases to create, as Bill Canals always said, mechanical paths to death. And rather than stopping the technology when the treatment that is being proposed really can't benefit the patient, or at least questioning whether or not we would want to continue that treatment when the effectiveness of the treatment and the burden may, for the patient, be determined to be too much. And then also on burden benefit, the addressing of the issues of time-limited trials. So again, the insertion of a feeding tube maybe to allow a patient to recover from an episode of pneumonia or an extended illness or some type of bowel or intestinal problem, and then that doesn't clear up, we make sure that at the very beginning of the time-limited trial, there's a very specific goal that is identified, and that it isn't just a matter of saying, okay, we're going to start the feeding tube and keep our fingers crossed. If keep our fingers crossed is not good enough, we need to be able to identify what specifically we're going to measure that time-limited trial by, and that we'll revisit it. And if it's not being effective, then we can do a good job of either stopping it or changing to something else and pulling it. So a lot of the questions for families around benefit and burden have to do with kind of life support or death prolonging. So most laws will simply say that there's, the presumption is that we're trying to extend life, and life extending treatment is what we're hoping to be able to do. And sometimes we have to face the fact that we're not necessarily extending the life of the patient, just simply extending the suffering and the dying process along the way. And those questions obviously come up most often in the areas of the ability of the patient who may be experiencing multi-system organ failure, the benefits of nutrition, the benefits of fluids, breathing in terms of the ventilator, elimination in terms of dialysis. For most patients who are involved in dialysis, the decision by the patient to discontinue treatment is usually not a sole decision that individual makes. It's usually a constellation of family members because they've supported the individual for usually many, many months in terms of that process. And then also in the terms of breathing dependence on a ventilator, obviously is usually a decision that's being made by someone other than the patient at the time that is actually stopped. So it's very important for burden and benefit to be understood at the time that the treatment is begun. In the area of fluids, a lot of it has to do with questions and concerns by family members around dying of thirst and those kinds of issues, and making sure that we're doing a good job in our palliative care programs or other ways to be able to say we don't need to be worried about that. We have other ways of making sure that we can keep the mouth moist, and that if there is inability of the patient to take off the fluids, that we're making sure that the patient understands or the family understands how those risks are associated with the ability of the patient to be comfortable and make sure that they breathe right, and we don't subject the skin to undue risks and breakdown and that kind of thing. Susan, you've kind of lived in this world for a long time. Then maybe something you want to comment on.
I think that it's important here to, again, focus on the patient and their family, because what we believe is a benefit, they can certainly believe is a burden. And especially in that trajectory where you're just on a decline in a crisis, a decline in a crisis, a decline in a crisis. At some point, I think it's important to recognize that the patient themselves may say enough is enough, and we need to be respectful and help them with that decision, and their family members with that decision. But benefit versus burden, I think, is a very challenging area for professionals to deal with, particularly those that have a long-standing relationship with that patient and that family. So,
thank you. So special considerations related to CPR and feeding tubes. Again, understanding the goal of the intervention. These are kind of these time-limited trials, making sure that we don't start something just because and hope for the best. That there is we're going to start this with this intention, and that goal of that intervention is clearly understood by both the patient and the family. So when that goal is not achieved or achievable, we are able to make a different decision, because that's not why we started it in the first place. So we weren't doing this, indefinitely. This was never intended to be a way for us to resolve all questions related to their care, and that we need to be able to go back and return to that specific goal that was associated with the intervention when it was executed. Exploring probable outcomes is also very important. You may have more than one option that you're considering, and making sure that the families understand that from the get-go, and the patient understands that there may be this that happens, and there may be this that happens, and we need to be able to kind of go with plan B or plan C if that's what that's what we face in the short term. And then when does it work, and for whom, and how long? So it's very important. This is a real benefit that clinicians can bring to the table in terms of, well, what your mom had is not, or what your uncle had, or what your aunt had is not what your mom has. And yes, it worked for her, but that's not necessarily what we're expecting in this case. So being able to talk about hopes and expectations in a way that allow the family to say, here's my hope, this is what we hoped for, this is what we're hoping for. And then for us to be able to say, okay, we get that, we understand it. What we want to do is talk about some expectations about what would happen if we do this, and for whom really can it benefit, and how long are we going to continue to try to make something achievable that obviously has a high risk of failure from the get-go, that we're willing to give a shot. And then default paradigms and false choices, that we really need to be guarded in making sure that we are not contributing to a misunderstanding of a treatment and a benefit of treatment simply because somebody read something on the internet, or again, why aren't you doing everything for my mother when you should be doing everything for my mother, and being able to talk about palliative care and other interventions as being everything, because that's really the only options we have available in terms of being able to provide the best care possible for this patient, and keeping that description in the positive and eliminating from our vocabulary things about there's nothing else we can do, she's failed this test, those kinds of things that put the blame and the burden back on the family, and being able to talk about it in a reasonable way that gets us out of these default paradigms, rescue medicine, and false choices for the patient. Okay, I'd like to spend a little bit of time talking about the Missouri out-of-hospital DNR and the Kansas hospital DNR, if we can spend a few minutes doing that. In 2009, when the actual regulations were beginning to be written by the law that was passed in 2007 for the out-of-hospital do not resuscitate law in the state of Missouri, the center, along with a number of people who were interested in pursuing the POLST initiative in the state, went back to the Department of Health and Senior Services and the Board of EMS and asked if we could get some clarification about whether or not the only way that anybody could receive an out-of-hospital do not resuscitate in the state of Missouri was using the purple form. And we specifically asked the question for two reasons. One is we anticipated the POLST initiative, the TPOP initiative, coming into being, and we wanted to be able to recognize that there was another way to do that, and we were using a standard of care that would allow us to be able to honor those wishes using that form. And the second was that when the law was adopted, there was a whole group of people that were not contemplated in the law. That group of people is composed of individuals who never appointed an agent and now can't make a decision. So the law only contemplates the individuals who have appointed an agent and then lose capacity, or an individual who simply can make an instruction and say, I want the doctor to sign a purple form. So we went back to them with the State Hospice and Palliative Care Organization, recognizing that there was a whole group of people that could not now appoint an agent because they hadn't in the past, and they could not now state that they knew they were sick enough that an attempt at resuscitation would not benefit them. And we asked the state, was your intention to prevent these people from being able to execute a do not resuscitate outside of the hospital setting, in a home setting, in a hospice setting, in a long-term care setting? And the answer we received from them was, of course, no. I mean, that we never intended for that group of people to be outside the ability to be able to receive a DNR. So in an instruction that we received from them, a clarification, they issued in a bulletin in the summer of 2010 that any valid order written on behalf of a patient for a do not resuscitate outside of the hospital setting can be recognized and is valid under the EMS protocols and under medical control. So there is no requirement that the only form that must exist for out-of-hospital do not resuscitate in the state of Missouri is the purple form, which allows then for us to proceed with the TPOP order as being another way for in a standard of care approach within a community to recognize that there is limitations in terms of treatment. The other thing that we wanted to do in that process was to bring to the table that it's not just on or off. It's not just about resuscitate or don't resuscitate. There are limited interventions that patients may wish. There are comfort measures that they may wish. There may be life-prolonging treatment that they wish when they don't want to be resuscitated. They still want to receive a feeding tube. And we wanted to be able to complete kind of the picture in terms of what a patient and family would want to seek, again, in any setting, within the community, transferring to the hospital in an ambulance, within the hospital setting, in skilled care, and back to long-term care or back to the community. So that was part of the reason then that we were moving in this direction to say we need a document that does that, which is what the TPOP order actually does in the POLST initiative. That we will go into greater detail, much greater detail, about what that order is and how it works and everything else in the series on November 30th. We'll spend a whole hour talking about how to have those conversations and how to execute the form and what it means and everything else. So please join us again at that time, because we're going to go into it in a much more consistent way. I also want to briefly talk about the DNR directive in Kansas. In Kansas, there is a law that deals with an out-of-hospital patient directive. There is no out-of-hospital do not resuscitate law in Kansas about orders. Within Kansas and within Missouri as well, a do not resuscitate order is valid when written by a doctor for a patient who has either expressed the wishes to do so, or the family, the agent, has agreed that a do not resuscitate should be in place. So that is a standard of care approach, and it is within the scope of practice of doctors to write those orders. It is now in the scope of practice in Kansas for even PAs to write those orders, and can be done. That order in the community setting outside of the hospital or pre-hospital is considered to be an order that is written by a doctor and acknowledged by the patient, or maybe in some cases not acknowledged by the patient. If it's on a script pad and it's a hospice patient and they're in the home setting, a doctor can write an order of do not resuscitate, and those have been written for more than 30 years, and thousands of them have been in play, and there's nothing the matter with that order being honored. In the initiation of the TPOP program, there is a new set of orders that we're asking doctors to sign, and in this case, actually asking family members, agents, or the patients themselves to acknowledge that this, in fact, reflects the wishes of the patient. So that order is also in place. The law itself deals with the patient, independent of anybody, and independent of them having a terminal condition, may instruct a physician that they want to initiate a do not resuscitate, and may do so. So in 1994, that law passed. It allows the patient to indicate to the doctor that they want a physician order for do not resuscitate. And in the case where it is of a religious conviction for that individual, the physician doesn't even have to sign the order that they've requested. It only has to be indicated by the patient that the patient, for religious reasons, wants this order, and then it is to be followed. And it provides immunity protection for EMS in following it. So that directive, that is a directive, it is witnessed. Physician orders are not witnessed. Patient directives, advanced directives, are witnessed. So that's another very stark distinction between the two documents. That directive is then used, can be used, in putting together the TPOP document, along with other reflections in terms of the living will or other directives that the patient may have initiated. So the transportable physician orders for patient preferences is the program that then embraces that, and we are now using a standard of care approach in initiating it across both states. I'm going to, I think, cover this in pretty short order here in terms of some background on this. We'll go into a little bit more of these in some of the other sessions, but probably not a lot. So I want to go ahead and provide you kind of the overview of the first segments, because we're going to get more into the nitty gritty when we can reconvene with you on the second series coming up on November 30th. The POLST initiatives, the Physician's Order for Life-Sustaining Treatment, has been around since 1991. It's now expanded into 44 states. Kansas and Missouri is the only bi-state initiative that currently exists. The two primary approaches that people have used in the past, that states have used in the past, is either to seek a legislative initiative, which means adoption of a law that enacts the possibility for us to be able to initiate POLST documents, and the other is a standard of care approach, which a number of states, half a dozen or so states, have used. We have decided to pursue that and have stayed with that decision since 2009. And just yesterday received some significant endorsement from the National POLST Paradigm Task Force about using the standard of care as the best way to proceed. It uses a clinical consensus model, and also then obviously pays attention to the scope of practice about which providers within the state can actually write those orders to achieve the goals of the TPOP, which talks about whatever treatments that the patient wants, which includes both pursuit of rescue attempts as well as limitations on rescue attempts. And it also then feeding tubes and other types of orders that may be in place in terms of admission to the ICU and those kind of things. So here's a description, a short description of what the standard of care clinical consensus definition really means. That it allows us to pursue a course without enacting legislation, that allows us to be able to provide kind of community by community using a coalition approach to make sure that we're involving all players on the spectrum, all on the continuum. So we've got long-term care involved, hospital people involved, EMS first responders involved, home care, hospice providers involved, so that all of those people are working along with their folks that they're serving and their patient populations to make sure that these wishes are honored throughout the course of care and wherever the patient resides in the community. And so that transportability issue is obviously very important. This is just a map of kind of where things stand right now. You'll notice that Missouri and Kansas are still light pink. They should go to the darker pink within the next, I think, couple of weeks. We received yesterday initial indication that we will move to endorsed status very soon based on the work that we've done with all of you in communities throughout both Kansas and Missouri. So if you need a little bit of background, kind of introduction to the POLST paradigm, basically it's end-of-life care planning approach, or maybe I should say now, since we're eliminating end-of-life, serious illness, care planning for patients usually in the last year of life that have answered the surprise question as no, that advanced care planning conversations between patients and healthcare teams and loved ones are facilitated and explored and matured, if you will, based on what the patient wants, that shared decision-making processes are identified, and then we begin to translate those goals of care and those wishes and preferences into actionable order sets that are then reflected in the patient's records, both in the long-term care setting, in the home care setting, and then presented to EMS at the time that EMS is called. So the goal of all of this is to ensure that patients receive the kinds of treatments that they desire based on their current medical condition. So as I said from the beginning, this is not a one and out. This is a progressive document which may change over time. And again, we'll go through that process with you on November 30th to talk about how those changes may occur as the progression of the disease happens and the awareness of the patients and the families in terms of how sick the patient is really changes during the course of their treatment. A little bit more history on us. The steering committee in Kansas City convened in 2009. We formed our first community coalition. We had doctors, nurses, clinicians, EMS, long-term care. We had some healthcare attorneys. We had home health and hospice providers. We even brought in some patient advocates to begin the process. And that time is when we chose the standard of care because we were serving folks on both sides of the line, and we really felt like the approaches that many states had taken in initiating legislation fell short in actually making sure that the transitions between settings was really not kind of being embraced by the clinical community in the way that it should. So when we made that decision, it obviously put an additional burden on us in terms of kind of making this work at the ground level rather than carrying around a stick and saying, well, there's a law now and you got to follow this. But I think it's the best course that we can follow in making sure that there's really adoption within community settings in a way that makes us responsible to each other and making sure that the handoffs occur in a more seamless fashion. We began work initially on our principles and description of processes, and we worked on our document design, which took us about the first year. We sought guidance from both the Missouri Department of Health and Senior Services, which we received in 2010, and the Kansas Department of Health and Environment, which was also received in 2010, about any sort of legislative barriers that may exist or regulatory barriers that exist, and received some instructions from them on how to make that happen, and we incorporated those into our procedures and our processes that we now have in place, and in the descriptions for our documents in terms of adoption within the healthcare settings, wherever you are in long-term care and in acute care settings, and EMS, and even some more sophistication just within the last few weeks from Kansas Board of EMS and the Medical Advisory Committee. The steering group began working on provider curriculum and training modules. One of the examples we used earlier today is one of the cases that we have in our long-term care modules that we'll be exploring with you as we further these offerings coming up in the next year or so, or even on site if you invite us to your location. We then began a pilot in Topeka, Kansas in 2010 that was recommended by the National POLST Paradigm Task Force, mainly because they felt that Kansas City was really too diverse and too many providers, too many EMSs, that kind of stuff. They thought we needed a small kind of with a community where we could actually kind of monitor whether or not things were working or not. So we did that. We learned a number of lessons, and especially in terms of the importance of champions at the local level and at the institutional level. So we've implemented some very specific steps in terms of making sure that we have institutional profiles and champions within the institutional setting. We then went through the next step of finding state endorsements and statewide organizations, including emergency physicians, long-term care associations, and home care providers, as well as hospitals and others along the way. And then we began responding to inquiries that were already surfacing from communities in both Kansas and Missouri on pulses everywhere else. Why aren't we here? And how can we make sure that we're able to get things moving? So we've continued to work in Kansas City with those lessons learned and then expanded beyond. This is kind of a quick snapshot of Missouri. I don't know if I've got the Kansas one in here. I'm not sure that this slide deck, I was able to capture that, but we do have a similar snapshot of Kansas, which is pretty robust. The starred ones are kind of where we are active, and obviously Rolla is identified on there. We're hoping to be able to expand to them, obviously the first part of next year. And things are still moving, I think, in St. Joe. And then just recently had some major interest by BJC on the the eastern part of the state, and hopefully we'll begin conversations with them very shortly about some a pilot project that will begin within the BJ system, I believe, at the first part of 2017. So they will actually kind of function in a pilot capacity for a while, and then we'll move from there to others. I apologize for not having the Kansas map. It's probably a little bit more spread out. There are 8 new communities that will be coming on next year, hopefully, through an effort that we're working on with Aledade in a number of rural settings. We're active in Wichita, Topeka, Kansas City area. Obviously, Salina has spent really this year kind of getting things moving and rolling out. Northwest Kansas, we have a number of communities up there, a number of counties coordinated through some multiple providers up there, including hospice services in the 16-county area, and then some other independent groups, Republic County and others that are working at kind of the more rural areas. The work that we'll be doing with Aledade will be focused primarily on primary care settings rather than on acute care settings or in long-term care settings. So we're looking very forward to being able to engage the community providers at the physician level in those areas with their project that's associated with their accountable care organization. So where are we today? We're still building our community coalitions and profiles. We have a system called RedCap that we use to do our institutional profiles. Again, we'll be talking more about that in future meetings. It allows us to do some data collection, helps kind of push out to you guys if you need a hospital policy development, you need sample documents in terms of EMS and those kind of things. So it gives us a way to see where you are, what kind of requests you have, and continue to take a look at folks that want to endorse this. Additional guidance and support that will be that we received in the course of the last 2 years and will continue. We now have a Caring Conversations Continued piece, which we can make available to you, which is basically a way for individuals who are considering that 1-year question to proactively go to their doctor and say, I'm interested in talking more about a TPOP form, but I understand you're the person I need to talk to, and I can't do this on my own, and I need to be able to talk to you about this kind of thing because this is important to me in terms of what I'm expecting in terms of my own care. We have a promotional video that's on our website that we can make available to you, and we have received significant clarification from the healthcare organizations in terms of responses to questions that were raised by the National Catholic Bioethics Center and the Catholic Health Association, helping us resolve some of those questions. And then guidance documents for Kansas hospitals and some additional information that we've had related to the Attorney General's opinion. For those of you in Kansas, those resources are available. Our plans for the future, obviously, are to continue expansion. Again, we'll get more into this on the November 30th session in that hour to talk about what we have available and how we want to proceed for the future with those of you that are in community settings. I want to reiterate that if you are interested in pursuing TPOP as the order set that you're going to use to reflect the goals of care for those patients that are so inclined to complete them, that we work with you broader than just yourself as an individual institution, and figure out how we can coordinate efforts across the different continuum of care, whether you're in the acute care setting or the long-term care setting or the community-based setting. We need to make sure that everybody in the community is involved, and we'll work with you on helping you establish kind of the goals related to your initiation of your coalition. Just quickly, the fee schedule, I wanted to be able to cover with you a little bit. I just skipped. Let me go back here. Oops. I talked earlier about the Medicare funding for advanced care planning. This is just a snapshot of the payment, the $99,497, the $99,498, the first 30 minutes and the second 30 minutes. But you can tell that actually there's not a bad payment mechanism in place. So if you need to know more information about that, we can provide you some. There are a number of different resources now that are available to you to be able to initiate those billing codes, probably even within your own systems. We can also help you with resources if you've got documents you want to share with your clients when you go through the process, both on the conversation side as well as kind of the goal setting side if your patients are seriously ill. The physician fee schedule is set. It doesn't have to result in the execution of a document, so you are not required to have that as an outcome. Just again, background on how the advanced care planning payment system works. It can be broader than end-of-life issues. It can be basically the naming of an agent and the importance of naming an agent, so it doesn't have to result actually even in the execution of a naming of an agent, but just basically not understanding about advanced care planning and what's the purpose of it and why would it benefit me and that kind of stuff if you need to spend that time with the family, especially for those that may already be compromised or family members who may have limited cognitive ability, or patients that may have limited cognitive ability, in terms of making sure that everybody understands what the purpose of this is. I mentioned earlier that there was a set of qualified healthcare professionals. Here, they're listed here: physicians, PAs, NPs, as I said earlier, and clinical nurse specialists. You can only bill if you're a Part B approved provider. So those of you that are already that, you obviously, if you've not initiated this, you might want to go to your institution and find out how you can. Obviously, the efforts that we're talking about here can easily be woven into that, and training in terms of the competencies and skill sets of your people who are involved in those conversations can be enhanced by participation in these kinds of events. There's a limitation on some providers being able to engage in this, specifically hospice providers, who it's considered to be part of the care planning process, so there are some limitations in terms of whether or not they can bill under this particular billing code. Also, there's no limits based on the frequency or the time limits set, but obviously those 30-minute increments need to be there, and there has to be good documentation, and there's some samples in terms of what kind of documentation you need to provide evidence for in order for you to feel comfortable about being able to get payment for that. Also, I want to make sure that you understand that if you're interested in pursuing these discussions with family members and patients, you can do it in association with a wellness visit. And in so doing, there is no cost copay to the beneficiary. So if your annual wellness visit is coming up and you want to provide this service through your clinic or your outpatient service, you can do that. And it can be an add-on, and you can still receive the payment, the $85 or $86. Or if it extends into an hour, the additional $75 and bill for the $160. And then because it's part of the wellness visit, there is no requirement that the patient have a copay associated with that. As I mentioned earlier, some of these resources that we're providing online and training will be available to you. We have a faculty listing that we'll be sharing with you again in the November 30th, and two DNPs will be providing that training along with myself, and the 3 one-hour modules is what we'll be offering. Resources for consumers are available on our website. We can make those available to you. Just let Matthew know that you're interested in receiving them. They are available for purchase in sets of 50 because they're paper-based, so that there is kind of an assured discussion back and forth between the doctor and the family. And then obviously this distinguish between the advanced care planning and physician orders is some resource materials that we can also give you for both Kansas and Missouri in terms of our ongoing conversations with EMS systems and the departments of Health and Environment and the Department of Health and Senior Services on the Missouri side. This is just a quick sampling of the additional documentation that's recommended. I don't want to go into it now because I think we'll be doing more of that on November 30th, but just suffice it to say that obviously you can't just say we had a talk and it was 30 minutes long. So it needs to be documented, and some of these ways of documenting that visit are available to you.
John, we have a couple of questions when you get a chance to check the Q&A tab.
All right. We're in good shape. So let me finish up here. Types of documentation that we will be facilitating, as I mentioned earlier, is a elicitation of goals, values, and preferences. We'll talk more again later on about responsibilities and roles of agents, and again, kind of taking a deep dive into informed consent and kind of how does this happen, both in the long-term care setting and in the acute care setting, which are the two professionals that we'll be having join us next time. This is just a sampling of the resources that we have on our website. Again, I invite you to go to our website and explore them. And then these are the content areas that I pretty much already covered. There's a kind of sampling of our faculty, description of the modules. The one that we're doing on November 30th will include Carol Buller and Maria Fox, who will be doing modules 2 and 3, and then I will be doing module 1. This will be free. It may be the only time we offer it free, so I encourage you to attend and take advantage of it, and we'll be busting that up as well as we move forward in terms of being able to download and get the training. So here are some contacts for you. If you got more questions and issues that you want to raise around advanced care planning opportunities from the center, and we'd be happy to respond to them. So that's it, and let me pull down the questions here. Okay. Mary Jo has asked, can you send me training information for advanced care planning? We're hoping to begin in our clinics and critical access hospitals in 2017. Is it mandatory to have a 3-hour training for quality healthcare professionals? Is a trained licensed social worker considered a qualified advanced care planning discussion participant? And does it have to be a PA or physician? Very good questions, Mary Jo. Let me first answer with saying there is no requirement, certainly that we have, in order for you to participate in training. We're just offering it as a resource for you. If you feel that you've already sufficiently been through that process and your folks have been through the kinds of training that they need to go through, there's no requirement that you be certified or designated to be able to do that. We're just offering it as a resource for you to be able to have available to you. So there's no mandatory training that I'm aware of. The qualified healthcare professional distinction is really kind of a license level that Medicare has chosen, and I assume that most commercial insurance companies will probably stay at that QHCP level. The licensed clinical social worker is not listed as a person who can actually conduct the visit that is billed, but that doesn't mean that we don't rely on licensed clinical social workers or licensed specialists or MSWs or anybody else to help facilitate that and prepare, and then that involvement with that individual, that 30-minute segment can certainly involve the resources and conversations and documentation that that individual has supplemented and provided, and that can also include chaplains and other sorts of individuals as well. But right now, licensed specialist social workers or MSWs are not listed as one of the individuals who can bill for the service. But obviously, we're relying on them to participate with the team in being able to elicit the information from the family system. Does it have to be a PA or physician? As I mentioned earlier, the NPs and clinical nurse specialists can also provide the service to the families. And okay, I think that's any additional question, please let us know or add to it, Mary Jo, if that's not sufficient. Okay, Mary Lou in Finito asked, does the billing piece require a full 30 minutes or can it actually be 16 minutes or more since it would fall into more than a half hour of the 30-minute We're not a billing agency, so I kind of doubt it. I think it has to be a full 30 minutes at least. And you're going to, Susan, do you know? I apologize. I'm not, maybe somebody else on the call knows, but my understanding was that it had to be a full 30-minute segment in order for you to be able to bill for that.
I don't know. I would hesitate to answer this. I think that's probably a question for a billing expert.
So I don't know where you are, Mary Lou, but I would check with the providers in your area. I will go ahead and incorporate that into our future discussions that we have here, and hopefully be able to provide that information just as a matter of course in the future. So make sure that that's clear. All right, any other questions or comments? Susan, do you have any final remarks you'd like to make?
I just want to thank everybody for their participation today, and hopefully this has been informative, and the center intends to be a helpful resource as the communities move through this initiative. So if you're not interested, if your community isn't even, you don't think it's going down the TPOP road, it's still information that is vital for patients and residents, I think, in both states. So thank you, John, for a very nice overview of the situation.
All right, we're hoping that most of you will join us again on November 30th, and you'll be hearing primarily from Carol Buller, doctorate in nursing from KU Med, who's been spending the last close to 30 years, I think, in the long-term care setting, and is actually in a collaborative practice and does a lot of this work with patients and families in that setting, in an outpatient setting, in a long-term care setting, in a continuous care retirement community. So some of you that were particularly interested in that segment maybe really benefit from her remarks. In addition, then Dr. Maria Fox will also be with us on the 30th. She is a palliative care specialist in an acute care environment, and has done a lot of work in the area of advanced care planning and elicitation of goals for seriously ill individuals. And really we'll be talking about how to move this conversation from kind of the advanced care planning wellness perspective into the serious illness conversation. And we'll focus a lot on the TPOP discussion, which also can be incorporated obviously into that billing process. So I invite you to join us again at the end of the month. And then finally in December, I want to remind you again that Dr. Karen Porter-Williamson will be presenting probably a shorter session on the Ariadne training that has been adopted by folks in Harvard and Boston at Dana-Farber and Brigham and Women's in terms of serious illness discussions to basically improve the skills of physicians and clinicians, clinical providers in basically having that serious illness conversation, which will partly flow from out of Maria's presentation that she does on November 30th. So we're trying to, tag these all together and make sure that they make more kind of a progressive sense to you as we document and archive these. We will let you know when they're available and hope that they are useful to you in your further work that you do in your communities. So please let us know what we can do to help. Get a hold of Matthew or me, and we'll be happy to follow up. Thank you again for joining us.